धर्म संस्थापना के देवता भगवान श्री कृष्ण के चरणों में मेरा नमन। परात्पर गुरु डॉक्टर जयंत बालाजी आठवाले के चरणों में मेरा नमन। आई एम very grateful and thankful to Western Ghat Literary Festival and all the organizers to have invited me here and given me this opportunity to interact and share my experiences with all of you. So today in my session I would like to deal with certain issues I would like to highlight certain issues about Gyan Vyapi case which is ongoing. I would be dealing with certain history and the cases which we have filed pertaining to Shri Krishna Janmabhoomi. Also I will be touching upon the aspects of Waqf Act, the Places of Worship Act, and whether we are actually secular, which the word secular was inserted in the Constitution in 1976 by 42nd Amendment. So are we actually secular in today's perspective are the issues which I'll be focusing on in today's talk. So starting first, yesterday I was traveling together with Mr. Anand Rangnathan, and it was a pleasure to be in the same flight with him. So I was just briefing him and narrating him about the issue that we say that we are secular, but the point is this, that secular is the only word in the Constitution which has not been defined. Secular is the only word which was debated by the Constitutional Assembly. In the Constitutional Assembly debates, 3 times this proposal of inserting the word secular was turned down. And then in 1976, 42nd Amendment was brought and secular and socialist word were added. So the point is this, that there are certain schemes which were, I was just narrating Mr. Anand Rangnathan about this dichotomy and about this discrimination. And I think he would be writing, I have suggested him this, that next time he'll be writing Hindus 8th class citizen. Now the second edition of this book will be coming because we'll be supplying him more details and more materials, that how Hindus are not just 8th class but 18th class or 20th class citizens, how the discrimination is continuing and ongoing. And the fact of the matter is that 5,200 crore rupees was the budgetary provision of central government from past so many years, and the recent budget of 2021-22 was 5,200 crores, where various schemes were floated for the benefit of minority communities. And this so-called minoritism is absolutely against the theme and against the ethos of the Constitution. When the word minority rights were discussed by Sardar Patel, by Jawaharlal Nehru, by B.K. Mukherjee, all of them said that there should be no special minority rights. When you are giving all the citizens equal right, or all the fundamental rights are available to everyone, then why are you giving special rights to members of minority communities? And let me tell you, before partition of the country, there were discussions in the draft constitution that there should be a special officer for minorities to deal with them with a separate perspective. But Sardar Patel said that if you are, and I am quoting him, that if you are such a well organized minority that you can get a whole country divided as per your populational strength, as per the strength of your population, then you do not want any minority rights in this country, and this country is not going to give you any minority rights. But despite that, Article 29 and 30 were added in the Indian Constitution, and today we are having a minority ministry, we are having a minority minister, we are having the Waqf board, and we are having 5,200 crore rupees which are being given by the government, by the central government. Recently the budget has been reduced after we had filed a petition in the Supreme Court. I am quoting Mr. K.K. Venugopal, who was the then Attorney General of India. He said that this matter must be referred to a 5-judge bench. It's a constitutional issue. And yes, and recently when our matter was pending in the Supreme Court has issued notice in the matter. When our matter was pending in the Supreme Court, the budget has been reduced to 3,200 crores. So at least I am happy that by raising the voice 2,000 crores of taxpayers I have saved. But the point is that this 3,000 crore rupees which are being spent on a minority should not be there. And the fact is that I am a Jain and I am saying that we should not, because I don't believe that Jains are minorities, and this was the greatest sin which was committed by Congress government in 2013 by declaring sections of Jain community as minority community. Jains and Hindus have always been together and they have been an integral part of one and the same belief. The only difference between Jainism and Hinduism is certain ways of worship which varies from India in various parts of the society. But Jainism and Hinduism, according to me, is no different. And let me tell you that Neminath Bhagwan is the cousin brother of Lord Krishna. He is the cousin brother of Lord Krishna, and if you visit Girnar Parvat, you will find the idol of Neminath Bhagwan, which was consecrated by Bhagwan Shri Krishna himself on the Tisri Tok in Girnar Parvat. So Jainism and Hinduism is no different, but the policy of divide and rule, and what Supreme Court said in Bal Patil case, that minoritism will lead to multinationalism, is what we are facing and what we are feeling. So therefore I believe that this entire scheme of minority schemes run by the central government must be abolished. And therefore this is the issue which I wanted to highlight, that Article 29 and 30 and especially Article 30 subclause 1 is the most draconian provision, and which is making Hindus live like 9th class, after 8th I am putting it 9th class citizen in this country. Because the fact of the matter is, see how, I just want to highlight how Article 30 subclause 1 works. If suppose a person is of a Muslim community, he can establish an educational institution, and right from nursery up to professional education, by reading Islam, Hadith, Quran and all the Islamic studies, he can study and become a doctor, engineer, and all the professional educations he can achieve. But that facility is not available to any Sanatani. I cannot read my Sanskrit, I cannot read my scriptures. I was listening to Guruji, so well read. The Anandi Foundation, he was giving his presentation here at 1:15. But we cannot have Gurukul Parampara, which is funded by the central government. We cannot have such institutions and then we can become lawyers and doctors. So this is the fallacy in the entire scheme and how Article 30 subclause 1 works. So now moving to the next issue is I would like to explain certain issues of Waqf Act and Places of Worship Act, and then I would demonstrate what our case is of Gyan Vyapi and Krishna Janmabhoomi. So I believe and I feel as a lawyer, after meeting various sections of the society, after meeting various members of the society, I believe that the Waqf Act 1995 is one of the most draconian provisions and most draconian statutes in our country. And the history of Waqf Act starts from Muslim Waqf Act 1923, the first enactment. And if you will compare the Muslim Waqf Act 1923 with the present Waqf Act 1995, there is tremendous difference. What Muslim Act, Waqf Act 1923 was enacted for was for administration of inter-see disputes between members of Shia community and Sunni community. So for example, if there is a dispute relating to a particular property between a Shia member and a Sunni member, then he can go to the Waqf tribunal, and for that purpose the Waqf Act 1923 was enacted. After independence, the first Waqf Act which was enacted was Waqf Act 1954, which was enacted by Congress government, and from there the draconian provisions started. And ultimately the Waqf Act 1995, which is existing today with amendment in 2013, is the most draconian law. And I would like to highlight certain statutory provisions which can show and demonstrate before us that how we have been discriminated and how there are laws in this country which are blatantly and openly discriminating members of the Hindu community. And the example is, and I am quoting each section word by word in a simplified form, and you can correct me if I am wrong. Section 4, 5 and 6 of the Waqf Act 1995. under section 4, 5 and 6 of the Waqf Act 1995, there is a survey which is conducted for the Waqf properties in every 10 years. And let me tell you that the cost of this survey is borne by the state exchequer under section 8 of the Waqf Act 1995. I want to ask a question to myself at this point of time, that whether there is any statute in this country, any government order, rule, GO, notification, bylaw, where any surveys conducted for the properties of Hindu temples. Rather, the survey is conducted that how rich the Hindu temple is and go and grab it. That kind of surveys are conducted. But there is no survey to see that how much properties are there for a Hindu temple, and that expenditure is borne by the state government. There is no such provision. And this provision, that survey of Waqf properties will be conducted by the state government, is in direct, and expenditure will be borne by the state government, is in direct contravention with Article 27, where the mandate of the constitution is that the state will not spend any money for a particular religion. Then moving forward, under section 40, subclause 1 and subclause 3, the Waqf board can declare any property as Waqf property. And let me tell you, if the property is of a trust or a society, look at the power which is given to them. If suppose they are acquiring I'm just giving an example to explain the provision. If suppose I am a society and I'm having certain chunks of land, suppose 2 acres of land, and I'm a society. And if they declare my society as a Waqf property, they will not inform the society. The information will go to the registrar of the society. And we know that what happens in the office of registrar of society or registrar of trust, all these communications are never communicated to the affected parties. So the result is, ultimately the person whose land has been declared as a Waqf property never knows that his land has been declared as a Waqf property. And if you don't challenge it, within 1 year that order becomes absolute. So this is section 40 subclause 3 for you. And under section 40 subclause 1, Waqf board has the power to declare any property as Waqf property. I was shouting about these provisions before this Tamil Nadu temple. When recently this example which came to light, that in Tamil Nadu a temple is there which was existing 1400 years ago, prior to Islam coming into force. Before that a temple was existing which was declared as Waqf property. This is a blatant example of how section 40 subclause 1 and how section 40 subclause 3 is misused and abused. And let me tell you, and it is not my data, the data is of Andhra Pradesh High Court of 2008, where the Andhra Pradesh High Court has gone on to record to say that the Waqf board is the third largest owner of land in this country. After defense and railway, the Waqf board is the third largest land owner in this country, and this is the data of Andhra Pradesh High Court of 2008. Now we are 15 years down the lane, and today if you will check the data, I don't know whether they are the first or the second. But the point is that we were mocked at by the judiciary, by the courts, by the so-called left liberals, when we used to say that Taj Mahal is a Hindu temple. Let me tell you that Taj Mahal has been declared as Waqf property by UP Sunni Central Waqf Board in 2005. The Archaeological Survey of India is in appeal in the Supreme Court. And the Supreme Court asked a question to the Waqf Board in 2018. Last this matter was listed in Supreme Court. And I remember Mr. V. Giri was arguing for the UP Sunni Central Waqf Board. The Chief Justice of India, the then Chief Justice of India, asked Mr. Giri that please show us the document when Shah Jahan made this Taj Mahal as Waqf property. After that, till today, this matter is never listed. So there is a municipal corporation in Surat which has been declared as Waqf property. Delhi, most of the lands in Delhi are declared as Waqf property. Mr. Anand Rangnathan once said on Times Now studio that please check whether this land is on, he said out of as a mockery, that please see whether this studio is on a Waqf land or not. Then later on he came to know that that area also they are claiming as Waqf property. So the fact is that the question which remains is that, have you given this power, I am asking, with lot of sense of responsibility, and I have asked to all the legal luminaries, the most senior advocates in this country, that is there any rule, notification, GO, bylaw, or forget any order where the member of any Hindu community, any Jain community, any Sikh community, any Christian community member has been given this power to declare any property as his own property. And then the person who, and after declaration, the communication will also not be made. And if the communication is made, then he has to challenge it before Waqf tribunal. Then moving forward, under the normal law for all of us who are sitting here is that if our properties are encroached, against the encroachment, we have to go to a civil court. We cannot take law in our own hands. We have to go to the civil court for removal of encroachment. And precisely that's what we are doing in Kashi and Mathura and Ayodhya. From 70 years we were fighting in Ayodhya to remove the illegal encroachment. In Kashi we are fighting legal battles to remove the encroachment. In Mathura we are fighting legal battles to remove the encroachment. But the power which is given to the Waqf board under section 53 and 54 of Waqf Act 1995 is that if the Waqf land is encroached, they can direct the district magistrate and the SSP or the state government to carry out their orders to remove the encroachment and submit a report to them and see to it that the encroachment is removed. I want to ask a question that whether any such power is with any Sanatani or any member of the Hindu community. Then apart from that, the member of Waqf board, then there is a Waqf tribunal which is constituted under section 85 of the Waqf Act 1995, where one of the members have to be a known scholar of Islamic law, and by default all the members of Waqf tribunal till date have been Muslims. So ultimately you are the judge, jury and the executor. You will declare your property, any property as Waqf property, and I have to challenge it before Waqf tribunal under section 85, and the provisions of and the jurisdiction of civil court is barred under section 83. I cannot challenge that order under in the civil court. So I have to challenge it in Waqf tribunal where the members of Islamic law are sitting, and they will declare that order as valid. Then under section 80 of the CPC, the British provision was, and it has continued till today under the present CPC also, CPC 1908, that if you have to file a case against the central government and the state government, you have to give them 2 months prior notice. This was the provision, and this provision remains intact in the statute books till today. Can you imagine that same provision is there for the Waqf board? If you have to file a case against the Waqf board, just like rulers, you have to give them 2 months prior notice that we are going to file a case against you under section 89 of the Waqf Act. Apart from that, the list doesn't end here. 3 more sections I will quote and I will move to the next issue. Section 101 of the Waqf Act 1995. Under section 101 of the Waqf Act, the members of the Waqf board and the mutawallis are declared as public servants. Meaning thereby if you even touch them, it's an offense under the IPC. No Shankarachar, Purohit, Mahant, priest, Pithadishwar or a simple priest also has been declared as a public servant by any government order till this date. But you have declared members of Waqf board as public servants so that they can do anything they want on ground and by statute, and no one can question them. Apart from that, for us, the law is that if any temple property is encroached and there is a shibayat and that shibayat is negligent, then you have to approach the courts of law within 3 years or within 12 years, whatever is the limitation period as described under the Limitation Act 1963. But for the Waqf board, there is no period of limitation. उनको जब सपना आ जाए कि कोई संपत्ति वक्फ संपत्ति थी, they can say yes, this is waqf land, and they can pass an order. For them there is no limitation. For us there is limitation. If we don't come to the courts of law within a particular period of time, our rights are barred. Our remedy is barred. But for them there is no period of limitation under section 107 of the Waqf Act 1995. And apart from this fact, let me tell you, ladies and gentlemen, that entire Punjab and Haryana and most of the parts of this country are burning because of this issue of section 108 of the Waqf Act 1995. Under section 108 of Waqf Act 1995, you know what has happened? The members, the refugees who came from Pakistan at the time of partition, they were in the properties of members of Muslim community who left to Pakistan. So ideally, after partition, they should have become the owners of those areas. So there, at that point of time, there was an act which was enacted by the central government, and the name of the act is Administration of Evacuee Property Act 1950. And the central government said that this entire area where members of Muslim community have gone to Pakistan, we will be the custodians as of now, and we'll see whom to give. Can you imagine that in 1984, the then Rajiv Gandhi government made amendment in the Waqf Act 1954 and introduced section 66H, H for Himachal Pradesh, and gave those entire lands to the Waqf board, and which forms today the part as section 108 of the Waqf Act 1995. So what is happening is the refugees from Pakistan who were believing that they will become owners of the land, today they are the tenants. And earlier they used to pay very meager rent of 30 rupees, 50 rupees or 100 rupees. Today the Waqf board is charging 1 lakh rupees, 2 lakh rupees as rent from them. So this is the draconian things which are happening. We have challenged the constitutional validity of Waqf Act 1995. Earlier we went to the Supreme Court, and Supreme Court always entertains most of the PILs which are concerning various issues. But this PIL, they said that you should approach the High Court first. So we have taken this challenge, and as of now 200 petitions are filed in various high courts, and we are filing petitions after petitions, and we are enlightening the citizens and our people that how this Waqf Act is so draconian. We have given a representation to the central government, but the fact of the matter is, why I am telling you all this today is that there may be a scenario that the judiciary of this country may not take appropriate steps at appropriate time, and it's already too late. As I've told you that the Waqf board is may become the first larger landowner in this country, and against this oppressive mechanism we all have to get united, and we all have to fight against it someday. Mr. Ranganathan has written a wonderful book, and I think books after books, series after series, articles after articles have to be written against this draconian law. Now moving forward, since I have a paucity of time, so I have to cover a lot of issues. So moving forward, I would like to demonstrate a little bit about what we have narrated as Gyanvapi case. What is our case? I don't want to take you all through various documents historically, because all of those documents, you know that how Aurangzeb demolished the temple, how our temple was demolished, everything is there on record. But I would like to first demonstrate before you that what our case is in Gyanvapi and what we are fighting for. So I would like to do it by making a map so that you can understand our battle little clearly. Am I audible? Yeah. So this Gyanvapi, I am saying that this is gate number 4, from where all the VIPs enter. This is gate number 1, from where the common people enter. It is horrible that this thing is there in today's era, but it is there. So this is Ganges river. So the idea is that from here you collect water and you come and directly offer water to the new temple. So this is the new temple, which was built by Rani Ahilya Bai Holkar in 1770, where we are offering worship as of now. And whatever I am speaking here is everything as per the settled historical records. It is not any disputed fact. So this temple was built by Rani Ahilya Bai Holkar in 1770, and I am right now demonstrating before you that what the present structure after building of the corridor of Gyanvapi looks, and how our fight is, and for what our fight is. So this is gate number 4. From here we enter. Like when I went for advocate commission, I entered from gate number 4 because of security reasons. Then we took a left turn. When you take a left turn, you find 3 vigrays. You find a shivling here. You find one more set of shivlings here. And you find a Hanuman Murti here. These are the 3 vigrays the moment you take left turn from gate number 4. Then little forward you go and you take a right turn, and you go and you meet this, and you get to this gate of new temple. So there is another gate For the persons who are coming from gate number 4, they go like this and they enter the premises of new temple, they offer their worship here and they go out. In middle of this area, there is this barricading. So this entire thing which I am building here is a barricading. Now this barricading was done by the then Mulayam Singh Yadav government in November 1993. And inside this barricading, there are these 3 central domes. And let me also tell you that this is the west side of the so-called mosque. This is the east side, this is the south, and this is the north. So behind these 3 central domes, we as Hindus are worshipping from November 1993 till this very day. We are worshipping the Vigrah of Ma Shringar Gauri. Earlier we used to worship every day in the year, but after this barricading which was installed in 1993, we are now worshipping once a year on 4th day of Vaishantik Navratra we are worshipping. So here there is Ma Shringar Gauri. Shringar Gauri. And inside this so-called, these are the 3 central domes of the mosque. This is the Wazu tank. In this Wazu tank we found Shivling on 16th May 2022. And this is the Tehkhana of Vyas Parivar. Tehkhana in Hindi we can say the cellar of Vyas Parivar. So this is the cellar of Vyas Parivar. Actually this mosque is on the 1st floor, so this cellar is virtually the ground floor of the mosque. But like you have to enter this cellar little bit so that you can offer worship. So let me also tell you one more fact, that Vyas Parivar was worshipping in this cellar till November 1993. It is only in November 1993 when Mulayam Singh Yadav government, in complete murder of the Places of Worship Act, threw the Vyas Parivar from this cellar, and this cellar is inside this barricading beneath the mosque. Thus Vyas Parivar was thrown out of this cellar who was worshipping inside the mosque, and they were dispossessed in violation of section 3 of the Places of Worship Act. And inside this premises in question, here there was a peepal tree which has been cut. There is Ganesh idol which was here, which has been thrown out. Hanuman idol was here. Hanuman idol was earlier there inside the barricading which is now here. This, as I told you, is a Hanuman idol. There were some shivlings which are inside the barricading which are now here. So now the so-called Anjuman Intizamiya claims that this is a mosque. So what we did is this. We filed a civil court in this, we filed a civil suit in the civil court of Varanasi. And we said that we were worshipping in the premises in question till November 1993. The Places of Worship Act has been enacted in July 1991. So in violation of, please read section 3 of Places of Worship Act, which gives a mandate that no place will be changed. And this right now I'm playing as a devil's advocate. First of all, I believe that Places of Worship Act is completely unconstitutional. But going by the interpretation which is being made out by Mr. Owaisi and various left liberals and seculars, they say that no place of worship should be changed and the religious character has to be intact on 15th August 1947. This is the narrative which we all hear. So the question is this, that who in violation of section 3 of the Places of Worship Act stopped the daily worship of Ma Shringar Gauri in the western side of the so-called mosque? Who till November 1993 stopped the worship of Lord Ganesh, Lord Hanuman, the invisible deity? And who in November 1993 threw us from the cellar which was existing right under the mosque? Is the grievance which we had before the civil court of Varanasi. And this civil suit was filed by us. Yes, so sorry. Nandi is here in the new temple, which is facing, so sorry. Nandi is right 83 feet. 83 feet from this shivling which we have found in the Wazu tank. Here is the Nandi, which is facing towards the shivling, this shivling. Now I'll tell the further story. So as per this map which I have drawn, As I told you that we asked for right to worship, and our suits are not just restricted to right to worship. We have asked for title also of this entire area. The khasra number of this area is khasra number 9130, which is the revenue record, which is the survey record. So we filed a civil suit in the Civil Court of Mathura, and we asked for an advocate commission survey, which is a provision under Order 26 Rule 9 of the CPC. And we said that inside this so-called Gyanvyapi mosque, there are various signs and symbols of Hindu temple. So an advocate commission survey is required. I must tell you that though we have various examples in our Indian judiciary of rejecting this demand, of calling this demand as communal, but there are certain rational judges also in the Indian judiciary. Honorable Mr. Justice Ravi Kumar Divakar, who has been now transferred from Varanasi to Bareilly, he passed an order of survey of advocate commission under Order 26 Rule 9 and said that survey must be conducted. And there were 5 dates on which survey were to be held. The dates were 6th and 7th of May and 15th, 16th and 14th, 15th and 16th of May 2022. And when on 5th of May, 6th and 7th of May, when me and my father were going to enter from gate number 4 to go and conduct this survey with the advocate commission team, I just want to picturize before you that before gate number 4, like from where this board is starting, there is a Maidagin Chauraha, which is very famous Chauraha, which is a stretch of around 1.5 kilometers. In this entire stretch of 1.5 kilometers, only members of Muslim community were there, and they were all pressurizing the members of survey team so that they can run away and no survey should be conducted. And why? And you know why this happened? Because the secretary of Anjuman Intizamiya, Mr. Yasin, gave a call that this survey will not, we will not let this survey happen, and we will fight against this survey. And I'll tell you why also they were resisting this survey. So I asked and I'm telling you a very genuine story. I asked my father that how will we conduct this survey, because this entire area is packed by members of Muslim community and they will not allow us to enter. And we were going in a taxi, in a hired taxi, and like taxi also was not able to go till gate number 4. This much of crowd was there. But I want to tell you this story and this courage. And this is not a courage of my father, of myself. This is a courage of each and every Sanatani, that if we believe in our cause, without even weapons, we can defeat them only because we believe that our cause is greater than their sword. My father told me that, Vishnu, keep moving forward. We will not go back. I am only able to see my Mahadev. You keep moving forward. And with that courage, we entered into gate number 4. The entire survey team entered into gate number 4. Outside there were a lot of nares of Nare Takbir and this and that. And I really don't know till today that how that survey team survived and how they entered gate number 4, because we would have been butchered and massacred. But it is only Mahadev, I believe and I feel, who saved us and who protected us to enter gate number 4. When we entered gate number 4, we earlier on 6th and 7th of May, we did the survey of the outer area of the barricading, and we did the survey of Ma Shingar Gauri, Nandi, which is facing toward the mosque, the Vigre of Hanumanji and various other areas. And on 6th and 7th of May, and let me tell you, the court order was that this entire survey will be videographed and photographed. On 7th of May, the members of Muslim community, the Anjuman Intizamiya, said that advocate commissioner is biased and this advocate commissioner must be changed. So advocate commissioner was also shocked that what biasness I have done, everything is recorded in the camera. I am writing whatever I am seeing. There is no issue of biasness. My report is not out. Anyways, they made this objection on 12th of May. Honorable Mr. Justice Ravi Kumar Divakar passed an order and he said that 2 more advocate commissioners will be appointed in the survey, and the survey will happen from 8 a.m. till 5 a.m. on 14th, 15th and 16th of May. On 14th of May, we did survey of the western wall, and let me tell you that the western wall is shouting and saying that it is a ruins of an old Hindu temple. Beneath these 3 central domes, we found the shikhar of Hindu temple which has been cut. In the so-called mosque, when we entered, there was a lot of calendars like Gyan Vyapi Mosque. And when we opened that calendar, beneath that calendar, Trishul and Damru and Shank were made. Then the so-called mosque was painted heavily to hide the original characteristic of Hindu temple. The pillars, there are two, as I told you, there is one Taikhana of Vyasji, and I forgot, there is one more Taikhana here, which is in control of Anjuman Intizamiya. The keys are with Mr. Ejaz. So we did survey of these two Taikhanas also, and we found lot of Sanskrit shloks, idols, destroyed and mutilated idols in both the cellars and both the Taikhanas. Apart from that, we found pillars of Hindu temple which were heavily painted. We found bells, and lot of proofs were found in the Advocate Commission survey. And on 16th, I can never forget that day. On 16th of May 2022, it was Monday, Buddha Purnima. This Wazoo tank, I was looking at this Wazoo tank from a far distance from the central dome of the mosque, and I was able to see a round circle wall, you can say. So I asked the Advocate Commissioner to do survey in the Wazoo tank. So no one ever thought that we will do survey of the Wazoo tank, because Wazoo tank was full with water. This Wazoo tank is of 3 feet, and entire 3 feet was full with water. So the Anjuman Intizamiya started objecting that there are a lot of fishes in the Wazoo tank, they will die. So I said that don't worry, I come from Jain community, we will take care of the fishes and we will do survey here. So the state government organized oxygen for the fishes. Can you imagine? Yeah, this has happened. The state government organized for oxygen for the fishes. The water was lowered down to 2 feet, and in 1 feet water, fishes were there with ample of oxygen. We took a stair. I'll just show you. From here. So this is the place where we found shivling. So from here till here, we took stairs to enter there. And when we entered those stairs, after around 370 years, when I and my legal team saw our deity, for some time I forgot that I'm a lawyer, and I shouted and said, Namah Parvati Pate Har Har Mahadev. And they were going to come and offer namaz at 11:30. And it was so very possible that they would have destroyed this important case property. So they would have destroyed this, was our belief. And under Order 39, Rule 3 of the CPC, there is a provision that court has all the rights to save a very important case property. So the Civil Judge Senior Division, on our request, sealed this entire area on 10:30 on 16th of May 2022. And first time in the Indian legal history, we were generally taught that if there is an order of Civil Judge Senior Division, you have to challenge it in district court. Against the order of district court, you have to go to High Court. Against the order of the High Court, you have to go to Supreme Court. But for them, law is different. First time in the Indian legal history, an order of Civil Judge Senior Division was directly challenged in the Supreme Court. And when the matter traveled to the Supreme Court, my father was hospitalized, and all the left liberals and the left media in the Supreme Court started saying that Vishnu and his father are taking the excuse of their ill health so that they can get this stay order extended. My father was actually hospitalized. Can you imagine? The media personals came in the hospital, in the ICU, to see whether he is actually hospitalized or not, and they took interview there. I am not naming the channels. But anyways, on the entire order was stayed for some time. On 17th of May, this order was interfered by the Supreme Court, and the matter was listed on 19th of May before the Supreme Court, 19th May 2022. I came to the Supreme Court with my father was still recovering from the asthma attack, because he is asthmatic and he entered into the Taikhanas. So I was, can you imagine, I was carrying the medical reports of my father that please give him 1 day's time so that he can come and address the Honorable Court. And the matter was listed, and the Honorable Court accepted my request, and the matter was listed on 20th of May For the first time in the Indian legal history, a order of civil court sealing an area was challenged, but ultimately the central government said that if this shivling is touched, there will be law and order problem in this country, and the order of sealing of Shivlingam remain intact. And first time in the Indian legal history, order of Civil Judge Senior Division was subsumed in the order of Supreme Court. And now this sealing order of this Wazoo tank is by the Supreme Court, and the order is dated 20th of May 2022. Now, what we did next? I am telling you because this is a little sense of achievement for all of us. We filed an application before the Civil Court of Varanasi, and the Supreme Court also transferred the entire litigation from Civil Judge Senior Division to the District Court, and the District Judge now became the Trial Judge. So we filed an application before the Trial Court saying that this area where we have found Shivlingam must be investigated. And because if we want our right to worship, the first thing is that we want to get it investigated, because the other party is not believing it's a Shivlingam, they are saying it's a fountain. So we said through non-invasive method, this Shivlingam must be investigated. The trial court rejected our request on 14th of October 2022, saying that this area has been sealed by the Supreme Court, therefore we cannot interfere with it. We said it's an erroneous order. We challenged it in a civil revision petition before the Allahabad High Court. 20 hearings happened in the Allahabad High Court, and ASI submitted a report of 54 pages which said that yes, this Shivlingam can be investigated, and this also can be investigated, whether it's a Shivlingam or a fountain, and without even taking a particle we can do this. Allahabad High Court on 12th of May 2023 passed an order that yes, there should be an SI survey of the Shivlingam, and many people have doubts in the mind that this is not a Shivlingam, this is a fountain. Many people have doubts. So I must tell you, and if someone is having very rational thinking, suppose a Muslim also, he will say that okay, you are saying it's a Shivlingam, I am saying it's a fountain, let it be investigated. But can you imagine, against the order of ASI survey of the Shivlingam and the fountain, Shivlingam/fountain, who came in appeal in the Supreme Court? The Anjuman Intizamiya. Anjuman Intizamiya said that no investigation is required, and this must not be investigated. It was the last working day of Supreme Court on 19th of May. The order of High Court was stayed by the Supreme Court on 19th of May, and it's going to come up on hearing on 30th of October, day after tomorrow. So we are going, I am going today for preparations for this only. So the fact of the matter is, then what we did? We did not rest our weapons. We said, all right, this Wazoo tank area, the order has been stayed by the Supreme Court, and when Supreme Court will give clearance, then only there will be an ASI survey. All right. Let the other areas up. We said that let the other areas apart from the Wazoo tank be investigated. Can you imagine? Like this was a long demand of ASI survey, and I still feel that it's some dream or something, because we moved this application before the civil court again on 16th of May 2023. The reply came from Anjuman Intizamiya on 19th of May. The civil court went for vacations in the entire June. The matter was heard in July for 5 hearings, and the Honorable District Court of Varanasi accepted our request, and on 21st of July, ASI survey was ordered of the entire area excluding the Wazoo tank. Against that order of District Court Varanasi, again, the Anjuman Intizamiya went to the Supreme Court. Ideally, they should have gone to the Allahabad High Court. And the argument was that we did not have time to go to the Allahabad High Court. The distance of Allahabad High Court from Varanasi is 100 kilometers. And the distance of Supreme Court from Varanasi is 800 kilometers. So they came directly to the Supreme Court on 24th of May without even a petition on oral mentioning. And the Supreme Court stayed the order of the District Court Varanasi for 2 days, that is till 5 p.m. on 26th of May 2023, and said that you go and file an appropriate petition before the Allahabad High Court. That too after lot of our resistance that this cannot be entertained in the Supreme Court. They filed a petition before the Allahabad High Court on 25th of May 2023. The Allahabad High Court, 25th of July 2023. The order of district court was of 21st of July 2023. The Supreme Court interfered on 24th of July. The matter was heard by the Allahabad High Court on 25th of July, 26th of July, 27th of July by the Chief Justice of the Allahabad High Court. The judgment was reserved, and on 3rd of August 2023, the Allahabad High Court said the order of district court is valid and ASI survey must be conducted in the entire area excluding the Wazoo tank. This order of Allahabad High Court was pronounced at 10 a.m. At 10 a.m. on 3rd of August, and at 2 p.m. the Anjuman Intizamiya again approached the Supreme Court. And can you imagine, I was also present at 2 p.m. in the Supreme Court. They were also shocked, because after the judgment I also came immediately to the Supreme Court because I knew that they are going to come. And they asked for an urgent overnight hearing of this matter. But due to awakening of the citizens, overnight hearing of this matter did not happen. The ASI had already reached the spot and the survey had started. On 4th of August, the Supreme Court also upheld the order of District Court and the Civil Court and the Allahabad High Court. So can you imagine, this is something unbelievable, that from 21st of July till 4th of August, within a span of 15 days, we won the demand of ASI survey from 3 courts. And today the ASI is conducting survey. There is a gag order which they have taken from the court that you should not tell what is happening in the ASI, and I am just holding my hands and I am not able to tell you what is happening in the ASI survey. But let me assure you that the ASI is going to file its report very soon, tentatively by 2nd of November, and it is going to be historic. I must also tell you that in Gyan Vyapi case, we are at the verge of victory. The moment ASI files its report, it will be a very fast track process, and we have all the clinching evidence, the historical records, the travel accounts, the gazetteers, the scriptural evidence, everything we will prove before the court by way of exhibits. This is a case which does not need much of oral evidence, because whatever has happened in 1670, no one can give oral evidence about it. Only it can be proved through historical records and ASI's evidences, which is an expert opinion under Section 45 of the Indian Evidence Act. But the fact of the matter is that then this case will have lot of progress. And now moving forward, I'll just take 5 minutes more. Okay. So in this context, what I was trying to narrate before you was, and demonstrate as a layman, was that Places of Worship Act 1991, we are understanding from the perspective of the media, the narrative which has been driven by the left liberals. What is written in the Places of Worship Act, we are not appreciating. What is written in Places of Worship, I believe, and I'm again reiterating, that Places of Worship Act must be repealed. But suppose the government does not repeal it and it remains in the statute books, what we as citizens can do, and what we did through our legal interpretation. We, in Kashi case, let me also tell you, in Kashi case, 50 hearings happened before the trial court that whether Places of Worship Act is attracted or not. On 21st of September 2022, we won from the trial court of Varanasi, and the district court held that the Places of Worship Act and Waqf Act is not attracted in this case. Anjuman Intizamiya against this order went to the Allahabad High Court. 20 hearings happened before the Allahabad High Court. Honorable Mr. Justice J.J. Munir passed a judgment on 31st of May 2023, wherein he held that this case is not barred by Places of Worship Act and Waqf Act. So this biggest achievement I want to share with you, that when the government repeals the Places of Worship Act, it will repeal, that will be an ideal situation for all of us. But we must come up with this narrative that Places of Worship Act uses the word religious character. And religious character has to be determined in a trial, in a suit. For example, to explain my statement, for example, if I enter into a mosque and I put an idol there, will the religious character of a mosque change? The answer can be only one, that no, the religious character of the mosque cannot change. And vice versa, if someone enters into a temple and he offers namaz there, will the religious character of temple change? The answer can be only one, that no, the religious character of temple cannot change. So that's why what is the religious character on 15th August 1947 has to be determined in suits. And let me tell you that we are not going to fight for only Kashi and Mathura. All the temples which were demolished in past by the invaders, we are going to fight one by one, very clinically, very professionally, and we will get it back. We will get it back. I have to brief you all about Mathura also.
But Vishnuji, when you do that for the rest of the temples, please, on the top of the list, put Adina Mosque of Bengal. That's one of the biggest.
Everything will come on, everything is on our list, and we will clinically fight it. Each and every temple which has been demolished and which has been converted into a mosque, we will fight it and we will get it restored. And this fight is to give a message that even though you demolish our temple, even after 500 years, 600 years, Sanatanis will rise and will reclaim back whatever you have taken. And I don't want to hear any lecture on secularism, because Jews and Muslims are fighting on Jerusalem for 35 acres of land. And we are in the similar position of Jews in Kashi Vishwanath. The Jews there worship in the western side of the so-called mosque, and the stones are thrown upon them. And no UN and no country or no big nation in this world from past 2000 years are able to solve the issue of Jerusalem. At least we have a living example of Ram Temple, where the issue which was 500 years old was solved by the Indian judiciary. And on 22nd of January, we are going to see a bhav inauguration of Ram Temple. So if Ram Temple can be inaugurated and can be reclaimed, it can be done in the case of Kashi, Mathura and many more temples. Now moving forward to the case of Mathura. See, Mathura's case is a more stronger case than Ram Mandir and than Kashi. Because, let me tell you, ideally if you all would be landowners here who are sitting in front of me, so you will be having some piece of land, or there will be sale deeds and all. Ideally, what is the concept we have? That if we have a sale deed, you will have possession. In Mathura's case, ironically, we have the sale deed, they have the possession. Let me tell you how. See, the history of Mathura is like this, that the temple of Mathura had always been on the eye of various invaders, and it was demolished many a times in the past. But lastly, it was constructed by Raja Bir Singh Bundela by a cost of 33 lakhs, and it was demolished by Farman of Aurangzeb in 1670. And the Farman said that all the small and big idols must be put under the stairs of Begum Shahi Masjid of Agra, so that when they go and offer namaz, it can be continually trodden upon. So then there was a battle of Govardhan, which happened in 1770. That area was captured by the Maratha Empire, and the entire area was under the control of Maratha Empire. And let me also tell you, in 1670, Aurangzeb demolished a temple. There is no historical record of Aurangzeb constructing a mosque. Please remember this. Then in 1770, Maratha Empire took control of this area. Then in 1803, the East India Company took control of this entire Mathura district. And in 1815, an auction happened of this 13.37 acres of land. The entire land which is very pious, and where we believe that the Karagar of Kans is there, where we believe that Lord Krishna self-incarnated himself is in this 13.37 acres of land, and there was an auction by the British government, by the East India Company in 1815, and Raja Patnimal of Banaras purchased that entire land of 13.37 acres in auction purchase from the East India Company. Then it so happened, a fraud happened with all of us. In the meantime, Raja Pandit Madan Mohan Malviya was a very important leader for all of us. Pandit Madan Mohan Malviya had a vision that in Sri Krishna Janmabhoomi a glorified temple, a lofty temple must be built. So he asked this 13.37 acres of land ownership from Raja Patnimal, the successors of Raja Patnimal. And 13,400 rupees was the cost which was fixed for this sale by the successors of Raja Patnimal to Pandit Madan Mohan Malviya. Why 13,400 rupees? Because the successors of Raja Patnimal were having some loans, and Seth Jugal Kishore Birla said that I will pay that loan and you transfer this land to Pandit Madan Mohan Malviya. This sale deed happened in 1944. The entire land was transferred to Pandit Madan Mohan Malviya, and Pandit Madan Mohan Malviya constructed a trust, which the name of the trust is, please remember this name, Sri Krishna Janmabhoomi Trust. This trust was formulated in 1950, thus, and in the meantime, Pandit Madan Mohan Malviya ji expired. And in 1950, the trust deed says that the idea of the trust is to make a lofty Sri Krishna Janmabhoomi temple at the so-called area, and the temple is lying in the ruins, is recorded in the trust deed of 1950. Then, in 1958, a fake organization was formed. The name was very similar, and the name was Sri Krishna Janmabhoomi Seva Sangh. Now, interestingly, Sri Krishna Janmabhoomi Seva Sangh files a case in 1964, and they say that in certain sections of this 13.37 acres of land, the members of Muslim community and Shahi Idgah Masjid have taken possession. So kindly remove them. On 12th of October 1968, a compromise happened between Sri Krishna Janmabhoomi Seva Sangh and Shahi Idgah Masjid, and the compromise was that whatever you have entered into, you be there, and we will build the temple in the other parts of the 11 acres. So as of now, out of 13.37 acres of land, around 2.5 acres is in possession of Shahi Idgah Masjid, and that's the area where still the Karagar of Kans is. So then after a long time, when me and my father were researching about it, we went to the civil court of Mathura. We got those documents, the deed, because when we used to talk about this to various sections of the society, they used to say, what are you talking about, Krishna Janmabhoomi? Compromise has happened. Everyone used to say compromise has happened, compromise has happened, compromise has happened. So we got the original copy of the compromise, we got the original copy of the decree which happened in 1973. All the records were in such a dilapidated condition that I can't even tell you. Like if I would have given that to you, no one in this world I can guarantee can read it. So we took a lot of microscope, lenses and all, we read it, typed it, put it in a proper form. And then I just want to say, and I'm not here appreciating, like it's not an issue of what I have done or my father have done, but as a son, I'm just telling that my father has 47 years of legal career. Every day he has devoted to Sanatani cause. Till this very day, when we are debating here, talking here, that man is sitting in front of the system from 9 to 9, working on these issues. So it is his hard work, and I am not appreciating him as a son, but I am appreciating him as a lawyer. It is his hard work that he formulated all these things. And जैसे मैं इसको ऐसे समझाना चाहता हूँ, अगर कोई चीज़ आपके सामने कोई आपको ब्रीफ करने वाला नहीं है, कोई आपको बताने वाला नहीं है कि यहाँ पे ऐसा हुआ है, ये उनकी अपनी तपस्या थी, जिन्हें उनको पता चला कि यहाँ पे फ्रॉड हुआ है. ये सिर्फ उनकी तपस्या थी. And we found that, ultimately what we found, that this entire land was given to Sri Krishna Janmabhoomi Trust. The ownership is of this land of 13.37 acres of land is with Sri Krishna Janmabhoomi Trust. Who the hell is Sri Krishna Janmabhoomi Seva Sangh to file the case and enter into a compromise? It's like a movie which we saw in my childhood days, Bunty and Bubbly. Two fraudsters had sold Taj Mahal. So something like this has happened here. And then we took out judgments of the Supreme Court which said that fraud unravels anything, everything. And if something has been achieved by fraud, you can challenge it at any point of time. So the compromise of 12th of October 1968 was challenged by us in the civil court of Mathura. And ultimately when that challenge happened, initially, can you imagine, we filed the suit for the first time in the Indian legal history. After 12th of October 1968, the suit was filed on 25th of September 2020. The civil court of Mathura rejected our suit at the threshold and said that Bhagwan Krishna ke asankhya bhakt hai. There are a lot of devotees of Bhagwan Krishna. If everyone will come to court, the judicial order will collapse. This judicial order did not collapse in CAA when 100 petitions were filed in the Supreme Court. But in Krishna Janmabhoomi case, if everyone starts coming to court, they said that judicial order will collapse. Ultimately, me and my father went for 45 hearings for appeal before the district court against the order of 30th of September 2020. And ultimately, the order of the Civil Judge Senior Division was set aside. And after a lot of labor, our suit was registered. Then we filed a petition in the Allahabad High Court because we understood that in civil court of Mathura, in civil court of Mathura, this can be never decided, because whenever we go from Delhi to Mathura, many a times there are strike, there are condolences, the case are not getting decided. So we filed the application under section 24 of the CPC before the High Court, and we said that if any foreign dignitary comes, the first thing we do and our Prime Minister does is to offer Gita to him. The person who has given, the Bhagwan who has given the Gyan of Krishna, the Gyan of Gita, for that battle we are fighting, and it is not getting taken up. So this is a matter of national importance. Please transfer it to Allahabad High Court for original trial like Ram Mandir. In Ram Mandir case, the civil suit was filed in 1950. The original trial was transferred to Allahabad High Court in 1989. After a lot of hearing in the Allahabad High Court, the Allahabad High Court on 26th of May has agreed to our demand, and this entire trial has been transferred from Mathura Civil Court to Allahabad High Court. So, against this, and very interesting, I will finish in 2 minutes. Very interestingly, when the matter was transferred from lower court of Mathura to Allahabad High Court, so we have actually curtailed 2 layers, because if the trial would have happened before Civil Judge Senior Division, appeal would have gone to the district court, then to the High Court, then to the Supreme Court. So 4-tier system is there. We have actually cut 2-tier system. So now the original trial will happen in the High Court, and then the first appeal will go to the Supreme Court. So against this order of 26th of May, the Shahi Idgah Masjid came to the Supreme Court. Again, the matter is listed day after tomorrow. I am going there. Day after tomorrow in the Supreme Court. And you know what they argued in the Supreme Court? They said that please transfer the trial to Delhi. We don't have funds to travel from Mathura to Allahabad. Can you imagine? From 7th of November, and I'm very sure that this is an open and shut case. Within 6 months maximum, I'm saying that we will get a favorable order in Krishna Janmabhoomi case, because the fraud has happened, the documents are speaking for itself, and all these things will be proved to hilt before the court. So I'm very, very thankful to all of you for giving me this opportunity for interacting with you. And again, I thank Western Ghats Literary Festival and all the organizers for giving me this opportunity. Once again, very thankful to all of you.
It was an enlightening and a delightful session, sir. Our best wishes for the success of the case. I request Basant Jain ji, who has come all the way from Mumbai for the program, to present the memento and felicitate Vishnu Shankar Jain ji.